Welcome to Embargoed, intelligent talk about sanctions, export controls, and all things international trade. I'm one of your hosts, Tim O'Toole, and with me today are Caroline Watson and Melissa Burgess, who also work with me at Miller Chevalier. Welcome, Caroline and Melissa.
Thank you.
So today we're going to have a podcast that is going to focus on the all things international trade. Because, generally on Embargoed, we talk about sanctions and sometimes we talk about export controls. But today we're going to talk mostly about CFIUS, the Committee on Foreign Investment in the United States, and kind of the background there. And then what some people call reverse CFIUS, the proposed rules that deal with outbound investment from the United States. And so, I think this will be an interesting contrast, mostly because, we had this big export controls and sanctions regime and CFIUS, and they deal with national security issues. And CFIUS has dealt with investment into the United States in the national security realm for, 30, 40 years now in some form. And we'll talk a little bit about that. But the outbound investment rules are designed to fill a gap, what people perceive as a gap in the national security realm, where we have U.S. persons making investment out of the United States. Now, sanctions deal with investment in certain countries, but these aren't sanctions. And export controls can deal with tech going into certain countries, but these aren't export controls. It's outbound investment regulation. So we'll talk about that, and they're proposed, and so we thought the timing was good. And we also had some developments in the CFIUS realm, because CFIUS came out with its new report on enforcement actions over the course of the last few years, and it's beefing up its enforcement. And so at the end of the podcast, we'll focus on enforcement and also a Supreme Court decision that might have something to say about that. It was in the SEC context, but it may have something to say about other agency enforcement. And with that, why don't we do a little bit of background? So why don't I'll turn it over to you, Melissa, to talk a little bit about CFIUS and kind of where it came from and where it's going for our listeners who may not be as familiar with the Committee on Foreign Investment in the United States.
Sure. Thanks, Tim. So CFIUS has actually been around for almost 50 years. In May of next year, it will be celebrating its 50th birthday. It was created by executive order, and interestingly, in contrast to the outbound investment program, it was a pre-IEPA, so pre the statute that we use, or the president uses for just about everything these days, it seems like. So it was actually an executive order under the Defense Production Act. And then it wasn't until 1988 that we really started seeing CFIUS and CFIUS authorities codified in statute. The big change that kind of everybody knows about and that really brought CFIUS to the forefront was FIRMA, so the Foreign Investment Risk Review Modernization Act of 2018. And that statute really kind of expanded and refocused CFIUS. So CFIUS's main purpose is to review foreign investments in the United States to determine whether they have an effect on national security. It's a pretty narrow-minded focus. It was broader initially, but that's really the focus. And in conjunction with that, it looks at foreign investments that are control transactions, so a foreigner, acquiring the entire business. What FIRMA added is review of non-controlling investments, as well as expanding CFIUS authority over real estate transactions, so where the only thing happening is a foreign investment in U.S. real estate. Another big change with FIRMA was going from a purely voluntary regime to a partially mandatory regime. And that meant that now, starting 2018 forward, certain transactions must be filed with CFIUS for review, which generally that is a transaction that involves a foreign government investor behind the scenes. There has to be a substantial interest by the foreign government in the proposed investment. And what kind of most transactions end up looking at is whether the U.S. business in the transaction is a manufactures, produces, designs, tests critical technology. Well, what's critical technology? It depends on how it's controlled for export. So FIRMA really made some big changes there in kind of joining export controls in CFIUS in a way that hadn't really happened before. And
let me stop you there real quick. So just for the listeners who may not be as familiar with CFIUS. So essentially CFIUS is kind of a multi-agency committee chaired by Treasury. And if I'm sitting in, say, Estonia, and I have some money that I want to invest in a U.S. business, you mentioned control transactions. So basically, if I'm going to take control of the U.S. business, CFIUS might come into play, right? Yeah, that's been for the last 50 years. That some form or other of that has been CFIUS, and essentially, if you want to buy a business that is next to a military base, maybe CFIUS will come into play because that has obvious potential national security considerations. One of the evolutions, it sounds like, is kind of a focus on, okay, so what businesses and what sorts of purchases have ramifications in the national security context?
Yes, exactly.
And that's kind of the focus that you're talking about with export controls. I guess the other interesting thing that you mentioned that I wanted to pause on, that maybe you can talk a little bit more about, is the difference between, so I'm this Estonian business person, and I'm going to buy a U.S. business. That is easy. That's a control transaction. I'm going to be in charge of the business. When you say that CFIUS kind of, with FIRMA, moved over to non-controlled transactions, talk a little bit about that.
Sure. So obviously there are a lot of ways that someone might invest that come short of completely buying out an existing U.S. business. So FIRMA gave CFIUS the authority to review most of, not all of, but most of those transactions that are somewhere less than a complete control transaction, but something more than an absolutely passive investment. So generally, to come within kind of the focus of CFIUS review and focus of CFIUS jurisdiction, those non-controlling investments will involve access to, in some way or form, access to the technical data or technology for that critical technology.
And that's where export controls come in, right?
Yes, again.
Right? So if I'm Estonian and I'm buying this business, or I'm putting a lot of money into the business, and it makes some sort of technology, and I want to get that technology in Estonia, like I couldn't get it sent there potentially without a license, but maybe I could buy into it. FIRMA fixed that gap, right?
Yep. And FIRMA also added a broader focus on critical infrastructure. So that's kind of some obvious things like telecommunications, undersea cables, but also a lot of defense production falls within that critical infrastructure prong. And then finally, sensitive personal data, which unsurprisingly is a very big national security concern, just because we generate so much data these days.
And that's kind of, for people who, again, may not be that familiar with it, and we might talk a little more about this later, but that was at least the stated concern with respect to the TikTok ByteDance transaction that was in the headlines, has been in the headlines relatively frequently in the last 5 years or so, was there was this data that came with the purchase in, what was the name of the U.S. company that was purchased by ByteDance?
Musical.ly.
Yeah. Musically. I don't know if that's right or not. My daughter, I'm sure, could tell me. But basically, you had this concern about data, right?
Yep. And that's actually, an important point to think about here is, so CFIUS looks at these transactions, and then what does it do? It's supposed to determine whether they have an effect on national security, and if yes, whether that risk that's presented can be mitigated or not. If not, then CFIUS will not clear the transaction. But if it can be mitigated, then CFIUS has to ask whether existing law mitigates the risk. So that's another way that export controls are really important to CFIUS, because export controls are essentially pre-mitigating a lot of risks associated to data transfer. But sensitive personal data, there isn't that same export control and licensing mechanism on it. So CFIUS has a lot more leeway under current law to focus on any sensitive personal data and say there isn't an existing mitigation mechanism for this, so we are going to impose one. And that can be an issue for whether it's social media apps, whether it's health data is of course extremely important. And then the question is, does HIPAA already fix the risk, or no, it's outside of HIPAA for some reason? Geolocation data.
The mitigation plan, just sorry to interrupt, but the mitigation plan in that context that you're talking about could be as simple as, like, the investors can't have any access to healthcare information, and there have to be procedures put in place so that the outside investors don't get any access to that, because it's really not a normal thing that an outside investor, even a shareholder, would have access to because of HIPAA, or if HIPAA doesn't protect against it because of other mitigation measures that are put in place, right?
Correct. I mean, you have to look at it in the context of the transaction, the rationale for the transaction. Obviously, if a big part of the rationale for the foreign investor was access to that data, maybe they won't be so happy with a mitigation measure that says you don't get to access it, and that might be one of those ones that's withdrawn because no one can reach agreement on it. But that is kind of the CFIUS standpoint is we look at other existing controls, and we use those controls to mitigate the risks if we can, and then we look at the gaps, and that's where we have the most authority. And that leads to mitigation agreements, and sometimes when they identify gaps, that leads to maybe we should look at some regulatory changes. So that's what we've seen, recent developments in CFIUS. There was a transaction somewhat recently that, CFIUS determined it didn't have jurisdiction over, because while there was an Air Force base near the property at issue, it didn't happen to be on the list. So that led to DoD reviewing the list of military installations that are relevant for CFIUS. And in 2023, we had a kind of minor update to the regs on that front. But that also led to congressional action. And earlier this year, the Secretary of Agriculture was added to CFIUS, so to that committee, on a case-by-case basis. So not necessarily every transaction will involve review by the Secretary of Agriculture, but agriculture-related transactions, the Secretary is going to play a much bigger role in those transactions.
And just to kind of fill in the rest of the committee. So basically, we don't have to go through all the agencies on the committee, but Treasury runs it. Commerce is on it, DOJ is on it, DOD is on it, State is on it, any other major...
Energy is a big one.
Yeah.
And then there are several that play supporting roles. They might get asked. For instance, Department of Labor at least kind of has a voice, even though it's not a main member of the committee. Additionally, parts of the White House do have a role.
And HHS, if you had like a healthcare transaction.
Correct. But the big ones are always DoD, Commerce, and Treasury itself. I think DoD plays a big role in approximately 60+% of transactions. Then energy, obviously, it will depend on whether there are energy-related aspects to the transaction.
Well, and one of the things that, FIRMA, which was this 2018 law that really tried to codify a lot of CFIUS and a lot of the common law doctrine around CFIUS that had built up in the 40 years before that. One of the express focuses that has already been at common law was on kind of countries of concern. And, even before 2018, but certainly after 2018, China was a focus of CFIUS and on foreign investment in the U.S. Can you talk a little more about kind of the focus on China?
Sure. And actually, one common popular misconception about CFIUS is that it really only looks at certain countries. On the face of it, it's a very neutral program.
Yep.
Any country, any non-US country is potentially within scope and subject to review. We have 4 countries that qualify as potentially accepted if the investor meets certain parameters. But we also the other bit of popular knowledge is that some countries are much more concerning than others. And so China being one of those biggest concerns, particularly when it comes to data and military technology, well, really any transaction. But that doesn't mean that other countries aren't a concern. It really depends on what the technology is, why the foreign country is seeking access to that technology. Obviously, countries with which the U.S. has somewhat more strained relations get a bit closer look for any of these transactions under review. But again, that doesn't mean that a NATO country is going to get an automatic yes and China is going to get an absolute automatic no. Though you can also guess that if you have a Chinese investor incoming, you should be presuming for filing before, instead of presuming against filing at the outset, at least. Whereas maybe some other countries you might presume have the opposite starting presumption and have to meet in the middle.
Right. I mean, all countries are created equal, but some are more equal than others.
Yes, exactly.
Purposes.
Exactly.
Before we start talking about outbound investment, I think China kind of is a good segue to that. But anything else you want to add about CFIUS before we start talking about reverse CFIUS?
Yes, yesterday, since we're recording on July 24th, CFIUS issued its annual report. For the most part, not groundbreaking news in there, a little moving of the needle. Always interesting to see the top countries for filings. Again, we mentioned that there are a few accepted countries, Canada, the UK, Australia, New Zealand, but still a very large number of filings come out of those countries, and it's probably because they don't quite meet all the prongs of that exception test. Another interesting thing that we will talk about is new enforcement actions, which CFIUS had only had 2 prior to 2023 in all of its history. And now we're seeing that, CFIUS is really making use of the enforcement authority it has. And that also relates to one outstanding notice proposed rulemaking that CFIUS has, looking at potentially dramatically increasing penalties for certain violations of the regulations. Currently, penalties are typically up to, so the greater of $250,000 or the value of the transaction. And CFIUS is looking at bumping that threshold up from $250,000 to $5 million. We'll see whether that one flies or not. But, part of that is, a kind of carrot stick approach of maybe we need a bigger stick for those scenarios where people are gambling on if we don't file, what will CFIUS really do? But I think we'll dive into that a bit in the enforcement discussion.
Yeah, and I definitely think it's a point we want to touch on, because I think you mentioned mandatory versus voluntary, and until 2018, CFIUS was a quote-unquote purely voluntary process, but the stick being that if you didn't volunteer to go through the process, the transaction could be unwound at any time if CFIUS found out about it. So the carrot was that if you get clearance, you don't have to come back.
Yep.
After 2018, you have mandatory disclosures. So there's a number of transactions that are mandatorily disclosed, and we can talk more about that later. But that is, I think, when we talk about CFIUS's caseload, the mandatory disclosures coming from places like, Sweden and Estonia and other countries that are friendly to the U.S., but there's still mandatory disclosures, has probably increased their caseload quite a bit. All right. Well, with that, let's turn to what we are referring to here as reverse CFIUS. I don't think we made up that term, but basically CFIUS's investment into the United States. And until recently, there had been no mechanism to deal with U.S. U.S. companies, U.S. citizen investment outside of the United States, other than potentially sanctions, which do have sometimes prohibitions on certain investments by U.S. persons. But otherwise, there's been no general mechanism for if you're going to invest outside the United States, is there a committee to review that? But basically now, complementing the inbound investment, there is now a proposed outbound investment regime. And with that, I'm going to turn it over to Caroline Watson to talk a little more about the reverse CFIUS process and kind of where it stands and what it looks like.
Thanks, Tim. Yeah, this outbound investment program is a fairly novel concept, not just in the United States, but also globally. There's only a handful of countries that currently control this kind of transaction, and that includes China, Japan, South Korea, and Taiwan. Congress has considered legislation on this issue in the past, including when it was enacting FIRMA back in 2018. But to date, it has only allotted funding for the development of the program. The program itself, what we're looking at today, was initiated by President Biden under an executive order that was issued under IEPA, which we've already discussed, back in August last year. Congress could still pass legislation on this issue, just like it did with CFIUS over the years, enacting various statutes to further empower CFIUS. So we could see that happening in the next couple of years, despite the fact that we've already got a groundwork for these regulations to be passed.
Well, and it also, that seems like it tracks a little bit the history of CFIUS, which was started by executive order, and then Congress got into the game afterwards. Is that basically fair?
Exactly. So it'll be interesting to watch over these next couple of years how Congress decides to act or not act to further shape this program. Right now, it is pursuant to executive order. In that order, Biden highlighted the national security threat that's posed by this civil-military fusion strategy that China has, and how China might exploit U.S. investment to achieve military dominance. And he highlighted that with respect to 3 categories of products or technologies. Semiconductors and microelectronics, which we're very familiar with the export controls that have been increasingly covering those kinds of technology. Also quantum information technologies, such as supercomputers. That's also been a topic in export controls lately. And artificial intelligence, which is the talk of much export controls, but hasn't actually been subject to much in and of itself. Now, Biden directed the Secretary of Treasury to issue regulations on these kinds of investment transactions, specifically with respect to China, although that could be expanded in the future. We'll see. That regulations that would prohibit certain kinds of investment and that would require notification for other kinds of investment. So now, in July, Treasury formally issued draft regulations that would implement this order, prohibiting certain investment and requiring notification for others. There are a lot of gaps in these draft regulations still that need to be filled, and the draft is currently subject to comment from the public. And that period of comment closes August 4th. So I think there's about 11 days as of today left to submit those.
So get your comments in now, or you're going to run out of time.
Exactly. The timeline for finalization and effectiveness is not entirely clear because they're not actually subject to the Administrative Procedures Act, which sets out a formal timeline for these kinds of regulations that are promulgated. Treasury is still following a process that looks like what is under the Administrative Procedures Act. So they might still allow for all of that time frame that's usually provided under that. And it seems, given how complex and technical the regulations are and the amount of input that they're going to have to sift through when they get the comments, seems fairly unlikely that they're going to actually have effective regulations in the next couple months, maybe by November, but that's not even clear if that would be possible. We'll see. As far as what's currently drafted, The regulations work similarly, but not identical to how CFIUS works. They prohibit certain investment, period. And then they require notification for other kinds of investment, but they do not have a review and clearance process like CFIUS has. Instead, they use the information that's submitted in the notification to inform Treasury and Commerce about trends in these areas, microelectronics, et cetera, and to further inform the development of additional regulations. So we will see more coming, I'm sure, over the years as this gets enacted. Now, there is a process for requesting an exception to a prohibition, and that would involve a review and issuance of some kind of clearance. But that is not a given. Obviously, it's an exception for a national security kind of transaction. On a high level, this notification and prohibition would apply to U.S. persons. That includes U.S. companies and U.S. individuals, and covered investment transactions that have a connection to China. And I use the term connection to China because the investment itself doesn't have to be in China, as we'll see, and that involve a certain list of covered activities. So with regard to geography, when I say connection, while it's aimed at investment in China,
and the term is countries of concern, right? It doesn't just say
exactly
China. It says countries of concern, and there's one country of concern so far. Right?
Exactly.
China.
Exactly. Now, that list could be lengthened, but given how specific the executive order was about the threat posed by China based on their civil-military fusion program, it seems like China is going to remain the focus of the program.
Right.
When they say China, it includes Hong Kong and Macau, and they say that very specifically in the order.
Which is consistent with the export controls trends, which basically moved in Hong Kong and Macau in after the national security law went into effect in, 2019, 2020?
Right, exactly. So I'll give you a couple examples in a moment that explain how investment outside of China can actually be covered by these regulations. But also, I think it's important to note not just U.S. persons are controlled in this in the way that it's drafted, but also U.S. controlled entities, such as foreign subsidiaries with U.S. parents, are subject
so it's
to
a
the
lot
same
like
prohibition,
like
and
the Cuba sanctions, like the Iran sanctions, where there are not only U.S. person restrictions, but restrictions that actually directly apply to foreign companies under control by U.S. persons.
Exactly. And there's very technical definitions on this, so I use the term U.S. owned and controlled loosely, but that's the concept, is U.S. Foreign subsidiaries with U.S. parents have to comply with the same restrictions. It covers a broad scope of activities. There's like a long list of different kinds that are prohibited and other kinds that are notifiable, but they generally concern the development and production of integrated circuits, ICs, which we colloquially refer to as chips, supercomputers and quantum technologies, and then certain kinds of artificial intelligence, or AI. And that's one of the areas that still needs to be further developed, the AI. It's very tricky to regulate that. And so they have a couple of alternative definitions in the draft regulations currently, but generally it's not a solid definition for purposes of this yet.
Okay.
To give you some examples, or sorry, what were you going to say?
No. I was just going to talk about kind of, I think it's right where you're going, which is, so I'm a U.S. company, or I'm a subsidiary of a U.S. company. I want to invest in one of those three areas. I want to invest in China. At this point, you're talking either a notice or a prohibition, potentially, that's under this statute. And I am assuming that the definitions in the proposed regs kind of give you a little more flavor as to what sorts of AI or what sorts of quantum technology or what sorts of of supercomputers or super chips are going to trigger these investment prohibitions. It's not just, I assume those are defined terms as part of the proposed regs.
Definitely. There's a lot of technical definitions for those kinds of technologies that are controlled. I would say the broadest technology control applies to integrated circuits. There's a set that's prohibited, and everything else is requiring a notification.
Right. So super chips, prohibition.
Prohibition or notification. Right.
Right.
Depending on how it falls under the definition. But in general, if you're in that space, it's probably covered.
And just building on that, there is, again, a hook to how some of those are controlled for export.
Exactly.
That is the threshold.
It all comes together, right? I mean,
it all comes together.
Which is good, right? Because I think before FIRMA, you had these export controls, but you had this situation where there was no, you might be able to make an investment that was reviewed under CFIUS, but at least expressly, there was no connection between, could you get a license to have that product shipped to your country? If so, why do we care? And if not, then we do care, because essentially the investment could circumvent licensing requirements. And so now that they're kind of all talking to each other, I think that's a good thing. And it sounds like they're going to build this into the reverse CFIUS.
Definitely. That is one of the arguments that opponents have to this kind of program, is that export controls are already in existence to control the flow of technology to China. But then the counter to that is that this program controls the inflow of either financing or other kinds of, what would you say, lending credence to and branding to the development of Chinese-based technology. So Chinese chips, which we see is what is happening right now with the level of export controls in that space. China is developing its own technology, and this is aimed at limiting how fast that develops.
Well, and in some ways, this is kind of like a modified sanction, right? Mm-hmm. Because the fact is that, you know, there are prohibitions on new investment in Russia. There are prohibitions on any investment in Iran. There are prohibitions on investment in some of the other sanctioned countries. And so this is, in some ways, there's a prohibition on certain investments, but it's much more limited than, say, the prohibition on new investment in Russia. But you essentially have then a notice provision that allows, you know, the Treasury and whatever the committee turns out to be that is reviewing this, to at least have some insight on what sorts of investments are being done in China. So in that way, it's not totally new, because there are prohibitions on new investment by U.S. persons, but it is modified in the sense that it's only certain items or certain categories of items, and then mostly it's about notice. So sorry to interrupt, but why don't you talk a little bit about some of the types of investments that might be affected by this proposed set of regulations?
Sure. So I'm going to start with some examples using a U.S. company investment that just show what kinds of transactions generally can be covered. The most obvious one is where a U.S. company acquires equity in a company that's incorporated in China, where that Chinese company is engaged in one of the activities, such as the development of integrated circuits. So that is the most obvious form of control that would apply here, because it's direct investment in China in this area. Now, there's other kinds of transactions that might not be as obvious to constitute an investment transaction. For example, if a U.S. company enters into a lease for a factory in China, where the U.S. company intends to convert that factory or facility to be used in the design or production of integrated circuits, that could constitute a covered transaction here. And that, you know, in sort of a greenfield sense. So a lease, other kinds of real property transactions, real estate, that could be covered. Or if a U.S. company enters into a JV, and now the JV kind of transaction entails JVs that are located anywhere in the world. So if the JV is located in Canada, but the other party to this JV is a Chinese company, and the JV is going to be involved in the development of quantum computers, that are covered. That kind of transaction could be prohibited, even though it's a JV in China. JV in Canada in this example. Geographically, this prohibition and notification requirement can apply to transactions that originate outside the United States. For example, if you have a German company that's owned or controlled by a U.S. parent, and the German company wants to acquire equity interest in a UK company, and that UK company is wholly and indirectly owned by a Chinese entity. And the UK company itself has a subsidiary that is engaged in development of AI for cybersecurity applications. This transaction could actually end up being covered, even though it's wholly outside of the US, wholly outside of China, and the target itself isn't even involved in the activities that are covered. It's subsidiaries. So you can see how far-reaching this starts to get based on these definitions. And in another example of this geographic scope, these rules can actually apply to transactions that are entirely within the United States. So a U.S. company acquires an interest in another U.S. company that itself is indirectly majority China-owned, and that U.S. company is engaged in the development of AI for one of the specified reasons, such as control of robotic systems. That could end up being covered. So I think that the due diligence implications for this are going to be huge.
So it's not just outbound investment, or at least not in the traditional sense. You can have entirely within U.S. investment that could be covered by these new regs.
Right, which is an area of comment currently, and Treasury acknowledges this issue and is considering whether to continue allowing that kind of transaction to fall within the scope. And they've asked for comments on that specifically.
Got it. Right. Well, why don't we, so that, I think that, is very interesting about kind of the proposed scope. I think that, it seems like it's far broader than just investments in China. Why don't we talk now a little bit about some of the similarities and differences between CFIUS and this outbound investment program, where essentially, as I'm hearing it, Caroline, you've got notification and prohibitions, but except for with the exceptions, not a lot of review, right? What about if I want to make a passive investment? So let's say I'm going to make a passive investment that just on the stock market. So essentially, I want to buy some equity in a Chinese company that engages in work in these areas, but I'm not going to do anything with it. I'm just going to put my money into that company. Is that going to be covered?
That's a great point. There are very key exceptions to these rules under the Outbound Investment Program, and one of them being acquisition of publicly traded securities, and that can be on a stock exchange generally anywhere in the world. It doesn't have to be a U.S. stock exchange. So it could be a China-based stock exchange. That kind of acquisition, as long as it's passive and doesn't entail anything else, such as some measure of control, that could be an exception to the notification or prohibition.
But, right, and this is where it all comes together. If that company is on the CMC list, Chinese military company list, OFAC list, it might be prohibited for that reason. Yeah, wouldn't be subject to outbound investment. So that would be the kind of the catch. But short of that, it sounds like outbound investment notification or prohibitions wouldn't apply.
Right. And I think there's another key exception to keep in mind. There's one for intra-company transactions. So U.S. parents and their foreign owned or controlled subsidiaries can engage in certain transactions without these notification or prohibition requirements. But that is a limited exception. So there's some nuance there. But generally, they have considered that intra-company transactions could be accepted.
Great. Well, it sounds like there's a lot of similarities between the two programs. I'll throw out a couple, but if anybody else wants to kind of chime in, I mean, obviously they're both national security programs, and at least as I see it, one is expressly directed at investment in China. The other one is at least, as a practical matter, focused on investment from China, although that's not the only country. How about the Treasury's role? I mean, Treasury runs CFIUS. Our experience, at least my experience, has been that Treasury is kind of the lead agency there. I've had CFIUS matters where some of the other agencies chime in, but I get the sense that CFIUS is really, that Treasury is really in charge of CFIUS. What about Outbound? I mean, do we think, I know Treasury's set to be the lead agency. How do we think that's going to work with respect to Treasury? Is it going to be as dominant as it is in CFIUS?
So Treasury is definitely leading the charge with regard to these regulations. When it comes to actually going through the notifications and dealing with all of those aspects of the program, I understand that Commerce is actually going to be involved in a support role with Treasury.
Which makes sense. I mean, to Melissa's point, I mean, now that export controls is, a big part of these programs and the tech that you talked about, Caroline, I mean, the, semiconductors, quantum computing, AI, that's Commerce's focus. It'd be hard to imagine that Treasury has the expertise to really play in those areas in the same way that Commerce does.
Definitely. And I think also just the volume that they're going to be seeing of information to go through. They need Commerce's expertise and manpower to do so. And Commerce is involved very similarly as it is involved in CFIUS. So it kind of plays a similar role supporting the review of transactions there. But Commerce is specifically mentioned in Congress's allotment of funding for this program. And to my understanding, Commerce has actually approached Congress requesting additional funding for the implementation.
Yeah, I think they only got $20 million, which is real money, but from a government standpoint, it's not a particularly big budget.
Right. Setting this up is going to take a good bit.
What about some differences? So, both agencies or both programs are going to have a lot of export control concepts, but do the Outbound regs adopt, verbatim all of the export control concepts that relate to semiconductors or quantum computing? I mean, how does that work?
Yeah, not as much, which is a little bit surprising. The Outbound regs really try to define terms internally as opposed to by reference to the export control regulations. They do have one or two references in there. One of them relating to a kind of technology that's covered. I believe it's one of the newer chip controls. And then they also incorporate a definition of knowledge from export controls into the regulations for outbound investment. So those are two areas where they directly relate, but otherwise it's a little less connected with export controls in that sense.
And let's turn to enforcement. I mean, how are the outbound regs, how do they propose to enforce the outbound regulations if you violate one of the prohibitions or you don't give notice when you're supposed to give notice?
This is one area that does need to be built out more in the regulations, from what I read. It's a very brief section, basically saying that violations can be subject to penalties under IEPA. And a lot of times in these regulations, we'll see it broken down by like, this kind of violation is subject to this kind of penalty. That violation is another penalty. It's much more specific. So I do think that's an area that they need to flesh out as they go along. Under IEPA, there can be penalties for willful violations of up to $1 million and up to 20 years imprisonment, but that's the extent of their discussion.
Got it.
On penalties.
And as you might imagine, I mean, they are just getting started on the regs. It's hard to figure out what the big enforcement issues are going to be, unlike CFIUS, which has 50 years of history. And Melissa, why don't you talk a little bit about kind of how CFIUS enforcement currently works and a little bit about some of the stats that came out yesterday with respect to CFIUS enforcement? Because I know one thing that FIRMA did was try and make CFIUS a little more muscular in terms of its enforcement, both branch and its practices, and kind of talk to us a little bit about that.
Yep. So there are kind of three ways you can violate CFIUS regulations, boiling it down a little. So one is failure to file a mandatory declaration. The second is misstatements, misrepresentations, material in a filing, and or other communication with CFIUS. And then the third is violating mitigation agreements. So one thing we're seeing with the enforcement actions that CFIUS undertook in 2023 is the four major actions were all about violating mitigation agreements. They also did identify some failure to file and actually received their first voluntary disclosure over a failure to file. But CFIUS had a pretty big focus in its conference last year that, mitigation agreements, getting them right, making them workable, and complying day one are all very, very important. And so it's not really a surprise that they're really focused on identifying and imposing penalties on failure to comply with those mitigation agreements, because again, the backdrop is those mitigation agreements are in place because of identified national security risks, and those are the way to mitigate those risks. So if you're violating the mitigation, you're probably causing some sort of national security risk, at least very broadly speaking. The details could vary a bit.
Well, and let's be concrete about that. I mean, so, mitigation agreements that we've seen where you essentially, as part of the clearance process, if you've got an outside investor, there's some mitigation agreement that says, but the outside investor, the procedures will be put into place within the company, the U.S. company, that prevents the outside investors from having access to personal data or for having access to controlled technology. And then you don't have those measures put into place, or, God forbid, you have the outside investors actually kind of rooting through the personal data files or rooting through or kind of getting the controlled technology. That's the sort of thing that could lead to a mitigation violation. Is that?
Exactly. And of course, there's a broad range of types of mitigation, but most more sensitive transactions are going to have a pretty long list of mitigation expectations. A lot of them, again, they're going to be cybersecurity related. And we actually see that in this year's annual report. A few additions to the list of common types of mitigation, like segregating computer networks. Not exactly surprising that would be part of it, but, a violation would be, we didn't actually put that firewall in place, or actually keep them completely separated. And another one is like conflicts of interest. So a lot of these mitigation agreements involve having external auditors, expectations for regular audits, and security officers. And in some of those, probably all of those agreements, CFIUS has very clear expectations about, no, this needs to be someone you've never worked with before. Because, you can't have too cozy of a pre-existing relationship where maybe they will turn a blind eye to because they know or they think they know what you're up to. So, CFIUS is pretty specific about you can't have conflicts of interest. And also other things like a newer entry on their list is processes for reviewing contracts involving third parties, especially if third parties are going to get access to data or systems. So that's something where, export controls might be a pre-mitigation for it if it's technology or technical data that's at issue. But if it's sensitive personal data, then export controls aren't really pre-mitigating that. So CFIUS would impose a condition on actually, certain companies cannot have access, or we want to pre-clear, or we want prior notification. So obviously, if you fail to notify CFIUS under the terms of your mitigation agreement, then you're looking at potential enforcement penalties. Like under IEPA-based programs, there is, some acknowledgement about the willfulness of the violation, the seriousness seriousness of the violation, but it's not quite as spelled out as, say, OFAC's regulations on voluntary self-disclosures.
Yeah, and one of the things that I found interesting, I looked into this once, didn't look into it in a way that I felt like was exhaustive, but went pretty far down this road. I couldn't find any criminal penalties for violating the FIRMA provisions.
And that is, kind of a unique feature. Well, maybe not unique, but comparing CFIUS to, say, other countries' foreign investment review regimes, the UK NSI Act has criminal penalties for individuals, and CFIUS doesn't. Is that going to change? It very well might. Maybe that's really the stick CFIUS wants, and instead it's looking at $5 million. But
well, I'll tell you how this came up. So I had a client once who we told them they had a mandatory disclosure. And they're like, okay, thank you. What if I don't disclose? And my initial response was, well, you'll go to jail. But the fact is that was not the right response, because I couldn't find any basis for which to, and that was, some of the other ones, I think you still could get into trouble with the criminal law.
Yeah.
For like, if you make a misrepresentation, then, 18 USC 1001 prohibits making a false statement to, a federal officer. And so I think you probably could get in trouble under those provisions for making a false statement in a CFIUS application. But for just not filing when you're supposed to file, I couldn't find any criminal penalties for that. And I couldn't even come up with a creative way of kind of looping some of the other more broad criminal statutes into a CFIUS criminal violation, which is why I found it interesting that they do look at willfulness, because again, willfulness is usually a criminal concept. It is in the export controls and sanctions space, but they look at it as one of the factors, but it does not potentially lead to criminal liability, as best I can tell. Yep. All right. Well, why don't we turn, since we're talking about enforcement already, I did want to kind of finish off the podcast with at least a brief discussion of a Supreme Court case that has something to say in the enforcement context. And that's the case of Securities and Exchange Commission versus Jarkesy, which is a case that the Supreme Court decided in June of 2024 that dealt with the SEC's enforcement mechanism, where essentially with an SEC violation, and there they were talking about securities fraud, the SEC had an option of charging you either through an SEC administrative scheme or charging you through by bringing an action to challenge the securities fraud in federal court, and essentially having the federal court impose whatever penalties the SEC convinced it to impose. And in the Jarkesy case, the argument was that the SEC's administrative process and forcing someone to go through that process violated the Seventh Amendment, which is the constitutional right to have a jury determine civil penalties, and essentially to go to a jury for whatever actions at law would have been actions in civil proceedings in front of juries and in front of judges, and to have a jury and a judge decide that rather than an administrative agency. And Jarkesy, the Supreme Court said, yes, that is your Seventh Amendment right. And in doing so, they talked about some of the aspects of this penalty that was imposed by the SEC that kind of made it clear that the Seventh Amendment applied. One of them was that securities fraud was essentially akin to a common law fraud action, that a civil monetary penalty was exactly the sort of penalty that juries impose, and that essentially the factors that juries would look at in terms of willfulness, in terms of kind of what went into the violation itself, was again the sort of thing that juries would traditionally pass on in the course of a trial that was in front of an Article III judge. And so the SEC's process for kind of forcing you into an administrative process that was entirely internal, was in front of kind of the same folks who were bringing the case, was not consistent with the Seventh Amendment right. Now, in the discussion, there was some discussion of this exception to the Seventh Amendment rule. They call it the public rights exception. And the Supreme Court, in talking about that exception, kind of first went through its case law to talk about how that exception had been applied too broadly over the course of the last 50 years and really kind of criticized some of its own cases for kind of having this flimsy public rights rule that seemed to swallow the basic Seventh Amendment jury rule. And so they made clear that going forward after Jarkesy, that rule is going to be applied more narrowly than it used to be, that it was going to really be the exception and not the rule. And they gave some examples, a few examples of things that still would fall within the public rights exception. The one that's kind of most relevant to us is, immediate penalties imposed by customs inspectors, which apparently at the time of the framing were pretty common. And so the Supreme Court kind of blessed those sorts of penalties that were imposed unilaterally and without the sort of, jury and judge process that the Seventh Amendment requires. But other than that, they didn't give us much guidance on when things are going to fall within the public rights exception, except to make clear it's an exception and not a rule. In reading through Jarkesy, a lot of the discussion really focused on the penalty scheme that the SEC had, but it was applicable to a lot of the administrative agencies that we deal with. And so there's CFIUS, that we've talked about. CFIUS's penalty scheme is basically that the committee tells you what the penalty is going to be. You have the right to essentially object and appeal that to the committee. And if you don't appeal it, that becomes the penalty. Although, like the SEC, there is a provision in CFIUS's regulations that also allows it to go to court to both enforce or potentially even get the penalty. It's not the most clearly written provision, but as I see it, it certainly allows it to try and go to court to collect, but it also potentially allows it to go to court to impose the penalty. Although, as a practical matter, I think CFIUS has imposed its own unilateral penalties. It seems to fit or look a lot like the SEC scheme. OFAC's scheme looks similar. BIS's scheme looks similar. The difference being that BIS has an administrative process. OFAC actually just unilaterally imposes the penalty, kind of like CFIUS does. But all of those seem to have some of the same problems that the Jarkesy scheme had or the SEC scheme had. I guess the question for you guys going forward is, where do we think or how do we think that this decision might affect CFIUS penalties? Because that's what we're talking about. Outbound investment penalties, because we've talked about that. And even broader, since this is embargoed, kind of penalties for OFAC or penalties imposed by BIS.
I could take a first crack at this unless Melissa has something.
Go ahead.
But I do think that, this particular area of regulation enforcement where foreign commerce and foreign affairs and national security are implicated is probably one of the strongest areas to argue that the public rights exception would apply outside of the ones that are very clearly referenced in that Supreme Court decision, which you've alluded to customs, and I think immigration might have been referenced specifically as well.
Yep.
But I do think they alluded to foreign commerce or foreign affairs as a potential area where this might apply. And so since those are the main bases for CFIUS and for the outbound regs, as well as OFAC and export controls, I think it's a possibility that a court could rule that the powers granted to the executive in this area are so strong that the Seventh Amendment right wouldn't be implicated or it would be overcome by the public rights exception. But it's so uncertain with the way that Jarkesy was written. I don't think it's very predictable how that's going to play out.
Yeah, and I think, to me, a lot could depend upon the case in which this comes up, because it's really hard to say that the Treasury Department, whether it's CFIUS or OFAC, has some sort of special expertise in deciding who's submitted a false statement to them, and whether the statement is false, right? And, one category of penalties that you just talked about, Melissa, was false statements to CFIUS. What is the special expertise that CFIUS has in adjudicating a false statement? And again, what is the special expertise that CFIUS has in finding mitigating and aggravating circumstances like willfulness. So I think that if you have a kind of a run-of-the-mill case where you've got somebody who's there for doing something that the agency has found is like fraud or false statement, or even like not filing a declaration when there was a mandatory filing, hard to see why that is something that, doesn't implicate the same sort of Seventh Amendment right that, you're talking about in Jarkesy. On the other hand, if you have a case that is really about kind of a detailed analysis of what constitutes investment in a particular industry in a sanctioned country, which often does require quite a bit of expertise, that might not be an issue that a jury would be, and a court would be potentially the most competent to engage in, because there are national security implications and the regs are complicated and they have foreign policy interests that are behind them. And, none of this stuff really existed at common law. And so I think that a lot of these cases, it's going to be hard to tell, because national security, I agree with you, Carolyn, that's the big distinction between these programs and the SEC program. But a lot of what Jarkesy said about, juries are just as capable of figuring out what's fraud as the SEC is, applies just as strongly here.
On that note, I wonder if that the national security, the power of that use of authority, maybe one of the reasons that we're seeing the presidential administration come out with these kinds of programs under IEPA now, because that gives explicit national security context to the issuance of those regulations. So, OFAC, export controls, outbound investment, all very clearly state national security as the premise.
But I think that's a great point. It's a great point.
So what you're really saying is we're about to run back to the 70s when IEPA was enacted, because TWIA, the pre-existing authority, was just getting misused. And so now we're going to have another discussion about we need to rein in the executive national security that's so poorly defined. Maybe we're going to add a little more to that so it's not national security because CFIUS or Treasury said.
Well, to that point, Melissa, another one of the grounds that didn't come up in the Supreme Court decision in Jarkesy, but was a premise of the Fifth Circuit's decision, was this whole non-delegation doctrine. So you essentially have this doctrine where, agencies are exercising, either executive or legislative branch power, but doing things that Congress really should be doing itself, that they have clear rules to define what it is that they're supposed to be doing. And, Jarkesy found that the SEC's administrative body violated the non-delegation doctrine because it was doing legislative and judicial things without any clear rules defining it. The definition of non-clear rules are some of the executive orders that we work with all the time. Basically, Treasury can designate anybody that it finds is operating in this sector and in any other sector that it decides that it's operating in. And, and I think OFAC takes pride in the fact that they don't provide any other guidance with respect to, if you're operating in a sector, we're not going to go after everybody. We're only going to go after some people. We're not going to tell you who those people are. And so, we spend hours trying to figure out the difference between different designations to try and figure out what is OFAC looking at. But at least under the non-delegation doctrine, Congress is supposed to tell them, and then they're supposed to look for those particular things. And so it may be that some of these national security principles do need to be fleshed out, but it's going to be under maybe not the Seventh Amendment, but maybe under non-delegation. All right. Any other last words on CFIUS, Melissa?
Nope. Except for, I think we can definitely expect some final rules coming out later this year. Congress is always interested, so we may see more congressional action on that, or maybe they'll focus on outbound investment instead, or, kill two birds with one stone, as it were, and tackle them both at once. But CFIUS is probably at a point where it's running fairly smoothly, it seems. It's, it has several years with FIRMA under its belt at this point. So it's more at that fine-tuning stage, now 50-ish years down the road, whereas the Outbound program is going to be going through all those growing pains, but hopefully have some lessons learned from the CFIUS process, from, OFAC sanctions processes, commerce export control processes. But that one, I think, is probably the bigger minefield of the two in terms of anything could happen, possibly.
Caroline, anything on outbound investment other than get your comments in by August 4th?
Get your comments in. I think there's still a lot of holes to be plugged in the draft regulations. I think it'll be interesting to see if they come up with a pilot program, kind of like how CFIUS started out after FIRMA. So that's one possible route for this program to take. And I just wanted to note that it's interesting to see that the EU is also looking at implementing a similar kind of outbound investment program with encouragement from the United States. And we've seen this kind of collaboration between the US and EU in other areas, particularly sanctions. So this is another area where I think the EU is also quite concerned about the military and intelligence capabilities of China and whether the EU needs to start doing something about that. So that's another area to watch. Does the EU start following the US's lead in this space?
That's a great point. And maybe we'll leave it there, except for to point out that maybe that, will warrant a sequel. We can get a bunch of our friends over from the EU and we can all have a little chat about, outbound investment, inbound investment, both in the US and in the EU, and kind of do a little bit of a compare and contrast with our friends across the pond. So with that, Caroline, thank you. Melissa, thank you. And to everyone who's listening, stay CFIUS and reverse CFIUS compliant. See you next time.
Thanks, Tim.
Produced by Heartcast Media.